Well, good evening and welcome. This is the first time I've logged into a comment. Molly, I can understand your level of excitement or lack thereof, but I want to thank you for being here with us. I'm going to take a couple of seconds and enter my name and information into the chat box. If throughout this process you have questions or concerns that you don't feel like typing into the chat box, please feel free to reach out to me directly and I'll connect with you or have somebody with my team reach out to you so that we can get some answers to your questions in a one-on-one consultation or whatever is most convenient for you. Name, email, direct line. And website. So anyway, Michael Gault with Bell Carrington. I focus exclusively on representing landowners in eminent domain and condemnation projects. I have a team of lawyers and staff, and we operate across the Southeast. Also, my team in this practice area focuses exclusively on the same types of cases. And so we found that oftentimes landowners like to join these town halls to learn a little bit about the eminent domain process, the particular project that we're talking about on any given day, and how we as eminent domain attorneys might be able to help our clients through this process. Obviously, if you're here with us now live, or we find that many of you come back and watch these recordings at a later date, whichever it may be, you're here with us today because of the NC 6587 corridor improvements and modernization project. This project is two things. It's massive in terms of budget and scope and size. We are talking about a project with a near $45 million total budget. Of that total budget, over $18 million is dedicated to right-of-way acquisition, which is obviously the portion that all of you as landowners are concerned about, the potential impacts to your property through right-of-way acquisition. Also, this project, I do this a lot. I do these town halls often, and I manage my team doing these projects often. It's not very often that I see projects that date back as far in time as this one has. This project has been kicked around, reviewed, planned, replanned, re-reviewed since the late 90s. And there have been a number of iterations since then. But now we're in the thick of things. We expect that some right-of-way is probably already kicked off on this project, but with something of this size and this magnitude, that will continue through the remainder of this year and into early 2025. I'll be curious to hear from some of you if you've received offers or if you've at least received contact from the initial representatives that come prior to those offers. But this project is a road widening project by and large. We're going to go to, in some places, 5 lanes with pedestrian lanes and turn lanes, raised medians. The footprint of the roadway is going to be significantly wider in many sections along this corridor. And unfortunately, because of that, many of you that are landowners in the area are going to have impacts. The government will need to take some of your private property for the public purpose of building the new road. And that's what we refer to as the power of eminent domain. That's a governmental entity's ability and right to take that private property for a public purpose. The government has that right. That is the most important of their rights. That doesn't mean that they're going to take or file a condemnation straight away. There's a period here at the beginning that they're going to attempt to negotiate with you as landowners. That process looks like a representative, usually a third-party representative of the state, will come to you along with an appraiser. There'll be an inspection. There'll be an appraisal, more than likely, and ultimately there'll be an offer to you as a landowner. But if those negotiations fail, be that on your own or if you're represented by an attorney, the state will have the right through the condemnation process to file a condemnation proceeding and to take the property that they need to take to complete this project. And in North Carolina, once they file the condemnation proceeding, once they deposit their initial offer with the court, and after an initial period of time passes, they have the right to begin construction on that property the same way that they would have had you been able to settle with them pre-condemnation. That is the entire process in a very small nutshell. It's obviously not that simple and not that easy, but initial negotiation and then ultimately condemnation. And we at Bell Carrington would obviously represent any of our clients from beginning to end, even if that takes us to the ultimate and final phase after the end of a condemnation case, which is your right as a landowner to a jury trial. Ultimately, if you're not able to talk and to come to terms and to agree on the amount that you're owed, then you have a right to take that case in front of a jury to have them decide. Sometimes that's beneficial, sometimes it's not. It would be jumping the gun to even have that discussion, but it is a potential part of the process. Now, we talked about government rights. We know that the government has the right to eminent domain. Your primary right as a landowner is the right to just compensation. Even though a governmental entity can take property like this for a public purpose, they have to pay you fairly and adequately for what they're taking from you, and that is wrapped up in the overarching phrase of just compensation. It's very difficult to tell you what just compensation is. There are so many factors that go into it, and I like to say that determining what that looks like is far more of an art than it is a science or an equation. There is no A plus B equals just compensation. It just doesn't work like that. Unfortunately, when the initial offers are presented to landowners, they are often presented in that way. We're taking X number of square feet or X number of acres. Here's what we found that square footage goes for in your area on comparable properties. Therefore, here's C. Here's what we're going to pay you. That sometimes, in fact, more often than not, fails to take into account potential other damages to properties. We represent landowners in residential impacts, commercial impacts, industrial impacts, and everything else in between. And those damages vary drastically depending on what type of property we're talking about. But it's important that you as a landowner have someone help you who can identify those impacts, who can identify those damages. One example that I like to use is, let's say you represent yourself in this case, or you go forward with a condemnation or an eminent domain proceeding, and you get to a number that you're happy with based on your reading of the plan sheets and your understanding of the process. And you sign those documents and you take that check. And in 2 or 3 years, construction is complete on the project, and you look out and the impact to your property is drastically different than it is today. Maybe you missed a change in elevation, or maybe you missed a change in access, or maybe there's just some intricate damage that you missed. And by the time you notice, it's going to be too late. And so that's one reason that we feel like having representation or somebody assist you through this case who knows what to look for, knows the potential pitfalls, knows the terminology, the vocabulary, the procedure, and in some cases, even the players on both sides of this is beneficial. You can't really put a price on it. And ultimately, at the end of the day, I feel confident that competent eminent domain representation will always put the landowner in a better position than they would have been trying to negotiate a case like this on their own. Quickly, I like to keep these things relatively short, 10 or 12 minutes. So I'll wrap up with 2 of my most important points. The first is there's no way that we could get down into the details of the impacts that you all are dealing with. I don't know who you are other than Molly in our chat box, but we're going to have other viewers, and your properties are going to vary drastically. Fortunately, at our firm, we have some proprietary in-house software that will let myself or somebody on my team pull up your property in real time, look at a GIS overlay with the plans sort of outlined on that mapping system. And so I can have a pretty quick, intelligent conversation with you on the phone in real time during an initial consultation about what the impact to your property may look like. I'll be able to see about how much land is being taken, and I'll be able to, just based on my experience, tell you how intrusive or lack thereof we believe that the particular impact to your property may be. So please call us, please email us, bellcarringtoneminentdomain.com. There are 2 places there for you, or 2 ways there for you to set up an appointment. You can do a direct scheduling through an app on that website, or you can fill out a fillable form with your name and contact information, and we'll reach out to you to set up that consultation. Again, you have my email and my phone number, so don't be scared to reach out to me independently. I help manage our team, but our team is filled with lawyers and staff that do eminent domain work all the time, and so we look forward to speaking with you. Those consultations are always free, no cost, no obligation. We want to talk to you about your property. It might make sense for us to work together. It might not. We don't know until we're able to dive deeper into each individual impact, really see what it looks like, find out who you are, where you are, how you're impacted, and then we can have a deeper discussion about if we can help you. The second is regarding attorney's fees. I can't speak for all firms that do this kind of work, although there aren't very many of us that are committed exclusively to eminent domain representation. But by and large, I found that most firms are similar. We work at Bell Carrington on a contingency fee basis. That means that you don't pay us upfront or out of pocket. There are no traditional retainers. There are no traditional hourly rates. Instead, we operate on a percentage of the amount of just compensation that we are able to obtain for our clients over and above the initial offer. I like to term it on the new money is how that just compensation calculation is calculated. It's not on the total amount received. Sometimes landowners are concerned about the cost benefit of hiring a lawyer, what they could do on their own with these hourly rates, cost me more than I could get on my own. Would the total percentage ultimately cut into what I could get on my own? And so we've structured a fee arrangement that only starts calculating on new money that would be over and above whatever you were able to get on your own through that initial offer. That fee structure does fluctuate slightly depending on the type of property, where you are in the process. Sometimes we have a fee structure that differs between eminent domain versus a condemnation filing versus a trial, but we can always have those conversations one-on-one and determine if that applies to your property. We welcome the opportunity to do that. And so those are my two sort of ending final points. I always like to open it up at the end. If we have live viewers and you have questions that you want me to try to address in this forum, I'll be happy to do that now. If you don't, again, you have my name, email, phone number, information. Michael Gault, the eminent domain practice group manager with Bell Carrington. We do this twice a week, these virtual town halls. We found that it helps provide some information in a mutually convenient format for both ourselves and for our potential clients and landowners in various projects. And so we appreciate those of you that are joining us live. I'd like to thank those of you that watch this later for your time and consideration as well. We would welcome the opportunity to speak with you and to work with you. Molly, thank you for that question. I have been doing eminent domain on and off since 2013. So 11 going on 12 years now. And that comes from both sides. I've represented governmental entities. I've represented landowners, but for the past 3 years, myself and my team have been committed to exclusively representing landowners. We no additional government representation. Okay. Well, thank you all very much for your time and consideration. I appreciate you joining me. I look forward to hearing from you. Don't be scared to reach out. You can send a text, send an email, or visit us on our website. I look forward to talking to you soon. Thank you.